I'll start by saying that everybody in this country, yourselves, myself, all Kenyans, it doesn't matter their tribe, it doesn't matter whether they are short or tall, everybody is entitled to justice before this court, before this land, before tribunals. It doesn't matter even somebody has committed sins in the past. Everybody is entitled to a process, fair hearing before a body that is able to be independent and be seen to be independent and above board. That concept of justice is inborn. You cannot separate the concept of justice from a person. You cannot. Even a 2-year-old can know if you're treating their 4-year-old sibling unfairly. They will cry out in protest. What are the rights you're talking about? What we are referring to is what is called natural justice. The right to be informed through a decision that is reasonable, through a decision that meets logic of the reason why a certain right by an administrative individual or body has been denied. Natural justice also dictates that everybody is given an opportunity to be heard before being condemned. You cannot be heard without being, you cannot be condemned without being heard, honorable members. And finally, this concept of natural justice also dictates that you cannot sit as a judge in your own cause. What does that mean? It means that any person, any individual that sits to hear any case in this country against anybody, because these are rights that we have to protect for everybody, because you never know tomorrow. That bench, that tribunal, that judge, one, must not have a personal interest in the outcome. So that you're sitting, and yet you cannot separate yourself from the decision that is going to be made, or you have personal interest, or financial interest, or any other manner you are involved in the outcome of the decision in a way that will be biased or prejudice the individual appearing before you. And what are we saying? The law allows the returning officer, here we're talking about the Mombasa County returning officer, to abide by certain principles that are secured under Article 10(2) of the Constitution in executing her mandate, so that she has to do the right thing, follow the law, hear a person, and ensure good governance. Article 47, administrative action has to be present. If it is not present, any action, any outcome has to be taken and interpreted in a manner that supports the agreed individual. So these natural justice principles I've talked about, the right to be a judge, to sit as a judge in your own cause, the right to get a decision that is reasoned, have been codified in our Constitution. We look at Article 20, and I'd like to take you there, because Article 20 is of fundamental importance to the matter before you. Because the actions with which we are appealing against, the decisions, are the actions of the returning officer as compounded by statements by the chairman of the IEBC, Mr. Chebukati, in his press statement of 4th of June 2022, in which statement he clearly condemned Honorable Sonko, knowing well that there is an IEBC tribunal to be established in which any grievance is supposed to be heard before. When you look at that statement, and you'll have opportunity to be taken through, you'll find that he has made he has addressed certain matters before court that Mr. Sonko and Wiper as a party have not had an opportunity to respond to. So Wiper had an opportunity and still has an opportunity when you look at our authorities, which you look at, to field a candidate of choice. And
an opportunity or a right?
A right and opportunity. And I referred to Article 20 of the Constitution. A right and opportunity. So when you look at Article 20 and you look at the press statement by Chebukati as I'm summarizing, you'll find that Honorable Chebukati, as the chairman and national returning officer, has overlooked all those natural justice principles together with the returning officer. They have overlooked rights that are secured because he attempted to interpret certain articles of the law without reference to the law itself or even judgment law or any rules at all. He made an arbitrary decision to the detriment of Wiper Democratic Party. So that article states that any interpretation, as was done by Chebukati, if I can just go. So the Bill of Rights, sorry. Yes. The interested party, and I'm glad to inform you that there will be a clip and you'll see the reason. Is the returning officer, but the returning officer, as she was leaving the station, said that her hands were tied because she was waiting for feedback from the legal department and IEBC, and that the chairman had pronounced himself with respect to that specific clearance.
Do we have jurisdiction over the chairman?
So this is our position. So first, to answer your question, it is the returning officer. Now, in terms of jurisdiction over the chairman and his pronouncement, as Wiper, we have looked at that statement, and our position is that this bench, from its very establishment, we are confident that it is an independent bench, and that any statements that have been made by Honorable Chebukati or any other person with respect to this matter is not hanging over the heads of the bench like the sword of Damocles. That you are independent and we have faith in that. We respect.
Officer, pursuant to our letter dated 7, a letter by Honorable Shakila that was forwarded to the returning officer Mombasa, indicating our displeasure or our disagreement with her decision to disqualify our nominee on two folds: failure to present original degree certificate and or certified copies of the same, and of most importantly, on the issue of breach of Article 17.
We are recording these proceedings for purposes of the proceedings thereafter.
Thank you. Part of the reason why this complaint was filed by Wiper Democratic Movement is because the nominee for Governor Mombasa was disqualified by the returning officer. 3 reasons were given by the returning officer. Number 1, failure to present an original degree certificate. Number 2, failure to present a certified copy of a certificate. And number 3, breach of Article 75 of the Constitution of Kenya. Chair and members, with regards to the 2 disqualifications, number 1 and 2, issues of the documents, you will see in your records, in the documents, there are comments by the returning officer with regards to the submission of the certificates by the interstate parties.
Perhaps Mr. Onyango, well, he said that will be addressed by the interstate parties.
There's a point, Chair, I'm making. There's a point I'm making, Chair. The point is, since those documents were received and acknowledged by the returning officer, it is our view that the returning officer purely relied on a third reason, that is breach of Article 75.
Also,
That
ground
is-
number 2, ground number 1 and 2 are no longer in contention,
In
according to you.
no, I was saying, according to me, the returning officer, if the returning officer wanted to disqualify the candidate based on the documents, those reasons would have been stated when the documents were being received. But clearly, she relied on the issue of Article 75, which Mr. Wanyaga has agreed on, and chair and members. If you look at the response by the returning officer, she clearly says that she awaited to get advice from the legal team, but by the time she was finishing up with the interested party, she did not receive any response from the legal team. So the question I want to ask based on the law, when she's doing clearance, to take into consideration matters.
To summarize what you said,
Yes.
the RO took an irrelevant consideration in arriving at a decision to reject the interested party.
That is the point, Chair. That is the point. Because she was never advised by anyone, any legal officer. Then lastly, Chair,
Consideration. The irrelevant consideration being matters before court. Is that the irrelevant consideration? That these matters, she ought not to have relied on them because they were in another forum,
Yes.
which ought to be
and she had
them.
not been advised by legal officer.
No, you may not know whether she was advised or not.
It is in a response, Chair.
Let's.
Thank you, Chair. Lastly, Chair.
Katisia,
Yes.
slowly.
Take on this. Sorry.
We have jurisdiction to intervene where a returning officer takes into account an irrelevant consideration. Okay?
Much of it.
I want to identify that irrelevant consideration you are saying the returning officer took in arriving at her decision. Identify it for me so that I write it down.
Thank you,
So that
Chair.
we write it down.
The relevant consideration is
Mhm.
a third reason, which is where she quoted and wrote breach of Article 75 of the Constitution of Kenya.
So why is it irrelevant? You've
Because,
identified what it is.
Yes.
Now tell me why is it irrelevant?
because two reasons. Reason number one, that consideration, the issue of breach of Article 75, is not part of the requirements which are before the RO to clear candidates.
Not part of requirements, not part of checklist.
Yes.
Second,
And number two, Chair, and members on this particular case are aware, there are pending matters in other forums. Chair, there are pending matters before the High Court, the legal bench, and even in the Supreme Court not been returned.
and all these things were told to the returning officer during clearance?
It appears she was aware.
No.
They were not.
Was she aware or not aware by your submissions that these matters were?
Because the interest party will submit in detail about that particular issue. I want to end by submitting Article 38(3) of the Constitution is very clear. And it provides that
When lawyers say it is very clear. Go ahead. I'm trying to make life the submissions. Okay.
Thank you, Chair.
Yes.
The RO ought to have been guided by reasonable restriction, because the law prohibits against the rights of an individual being restricted and reasonable.
So you're saying the RO did not exercise restraint as was required of her under Article 38.
Yes,
Okay,
yes.
I got it.
That is my point, Chair,
Anything else?
and I'll allow my colleague to summarize our submission. Thank you, Chair.
Your Honor, may I? I'll pray for your indulgence given the interjections by the bench. I don't know if that one will be taken into
You are even
consideration
taking
in the
that
time.
seconds more.
The time.
Go ahead.
Thank you, Mr. Chair. Now, for easy reference, I'll make a lot of reference to our list and bundle of authorities, which is dated the 15th of June 2022. Now, I wish to address this tribunal specifically on the issue of political rights and legitimate expectation. Now, my first is to compete for political power. Now, for that proposition, I refer the tribunal to the decision, that is decision number 1 in my list, that is the Diana Kethi Kilonzo case,
We know about it.
and specifically paragraph 163
We know about it and its history.
of the legitimate expectation and interest of the political policy and conflict, where the court affirmed the said principle, and I refer specifically to paragraph 147 of that authority. Now, thirdly, I submit that the people of Mombasa, just like every other Kenyan, have an inalienable right to choose freely and be represented by a leader of their choice in the exercise of their fundamental rights and freedoms under Article 38 and 81A of the Constitution, which includes the freedom of choice and for choosing among a pool of contestants in an election. Now, in determining the present complaint before the tribunal, I urge the tribunal to interpret and apply the law in tandem with the express provision and spirit of Article 20 of the Constitution, which mandates this tribunal to apply the Bill of Rights, which includes political rights, in a manner that develops it and permits the extensive enjoyment of the same without any limitation, so that tying that to the actions by the returning officer while exercising that power as an arrow, she was bound by the provisions of Article 47 and 10 of the Constitution, so that she ought to interpret and apply the law in a manner that permits the full enjoyment of all these rights under Article 38 and 81 of the Constitution.
3 more minutes.
Again, Mr. Chair, I submit that any such interpretation that would result to a limitation of Honorable Sonko's, the wiper parties, and the people of Mombasa's fundamental rights and freedom would be contrary to the Constitution. Again, in terms of limitation of fundamental rights and freedoms, I submit that number 1, the same must be founded in law. Secondly, the same must be reasonable and must not in any way take away that right. And thirdly, and more importantly, derogations from fundamental rights and freedoms are short-term deferment measures of rights and only granted during times of emergency and urgency. So that in this case, there is no urgency or emergency to warrant the denial
Oginga.
of this right.
Oginga.
Yes,
Thank you.
Mr.
Those
Chair.
are very nice, big constitutional principles, but can I allow me to summarize them for you as I did for your colleagues? You've identified
Yes.
to compete for political power and represent a candidate of its choice. That's the first legitimate expectation. The second legitimate expectation you raised is that of the Mombasa people to choose a leader of their choice without restriction. Okay? And if I get you, all these things done by in relation to the present case, the returning officer in declining Sonko's candidature has breached those 2 legitimate expectations. Do I get you right?
Yes.
Good. And any derogation from all this must be within law, within the parameters of what you have given us.
Yes, Mr. Chair.
Including ending with urgency.
Yes, Mr.
Is
Chair.
there anything more you wish to add?
Yes, Mr. Chair. I
In a
refer.
minute.
It's
In a
take
minute.
for
It's
your
very
guidance.
important.
3 minutes.
No, 1 minute.
Okay, Mr. Chair, for quick reference, I've cited two, then I've equally cited the Yale Law Journal, which talks about the right of appeal. Now, Mr. Chair, owing to the time constraints,
Is there none from the University of Nairobi?
none, Mr. Chair. Now, as I summarize,
That's a
Mr. Chair,
good question.
owing to the time constraint, let me refer the court to the decision, that is authority number 7. Mr. Chair, permit me to read it. And specifically, that is paragraph 108. That is the decision in
John Dirango Kariuki.
Commission on Administrative Justice, John Dirango Kariuki.
I acted for the commission in that matter.
Yes, that is why I've cited this, Mr. Chair, because this is an important proposition that will determine the issue on Article 75 and the right to appeal. And permit me to read this, Mr. Chair. In so concluding, I have had to weigh the weight the Constitution has placed on the need for integrity in leadership for good governance against a similarly weighty premium the same Constitution has placed on the protection and advancement of fundamental freedoms and rights, in this case, political rights. The need to promote fundamental rights and see to the realization of the potential of all human beings will tilt towards ensuring that even a convict must have his day in court, including the very last day. That appears to the spirit of Article 99.3 when it talks of all possibility of appeal being exhausted. And I urge the tribunal to also consider Article 193.3, which permits and recognizes the fundamental tenet of an appeal and makes it a bar against any such disqualification. I urge the tribunal to allow the complaint. Thank you, Mr. Chair.
Article 20 and 38 of the Constitution where political rights of interested parties are threatened with violation. Your Honor, under Article 20, it is provided to extent consistent with the nature of the right of fundamental freedoms are involved, ought to ensure that it accords him the greatest opportunity to enjoy fundamental rights. Your Honor and Honorable Commissioners, the rights, fundamental rights, which Article 20 applies, the principle underlying Article 20 applies. So it should. Yes.
Enjoyment of the rights should be the norm and derogation should be the exception.
Yes, and actually the principle that we are actually emphasizing on is a principle to be adopted, to be applied by any state officer when dealing with the question of enjoyment of fundamental rights of a person. So the principle ought to be that that state officer ought to ensure that it applies the greatest extent. It may also need to go out of its way to ensure that these rights are availed and are not contravened. Your Honor, we are dealing with a case where the returning officer rejected the interested party's nomination papers on 2 silent grounds. And although I've heard my learned friend say that every issue is confined to Article 75, Your Honor, on the paper, on the document by which the returning officer rejected the interested party's nomination papers, they indicated that they rejected on the basis that they did not produce the original certificate, the degree certificate. Your Honor, on the question of that original degree certificate, we wish to submit that in the first place, that issue, the original degree certificate, was not part of the checklists provided. And we invite this tribunal when it retires to look at the checklist of the documents that were required. That the certificate was not run. Number two, Your Honor, the certificate, a certified copy of that certificate was provided at the inception. And that will be found in our supplementary list of documents. In our supplementary list of documents, where the degree certificate is shown to have been certified, and that is at page, it's not page dated, but you'll find the degree certificate from Kenya Methodist University. That degree certificate is certified by an advocate. There was no provision whatsoever that a degree certificate ought to have been certified by any other party, and that advocates were precluded from certifying that document. Under the Advocates Act, advocates are qualified to certify documents.
Is it Advocates Act or Commissioner of Courts Act?
And even the Commission of Courts Act, and also the Advocates Act. And it was not a requirement that that particular certificate ought to have been certified by the institution from which it was obtained. So basically, that particular condition was neither here nor there. It was actually a condition in contravention of the principle under Article 20 of the Constitution, and also the principle under Article 259 of the Constitution, where any officer, any person applying or interpreting the Constitution ought to promote and protect the purpose of that Constitution. So basically, our argument is that to that extent, the returning officer actually contravened and ignored the principles underlying the Constitution. Further, Your Honor, on the question of the fact that on the question of why and how Wiper Democratic Party is actually jealously in court in this tribunal, championing and seeking to complain against the action of the returning officer, is that the Wiper Democratic Party presented a list of candidates for nomination as provided under the Elections Act within the timelines prescribed. And Your Honor, upon presentation of the same, the name of the interested party was forwarded. The name was actually cleared, and the interested party was actually given a schedule and invited to present its nomination papers. And that's how Wiper is interested. So there was that legitimate expectation that its member cleared as a candidate. Now, sorry, yes, yes.
Wiper have done their case.
Yes.
They are appearing to the interested party to kill the candidate of its choice and the legitimate expectation of the people of Mombasa to choose. Address us on the legitimate expectation of the candidate.
Yes, when the candidate presented
Because you are
his
appearing for the candidate.
when the candidate presented his nomination papers, when the candidate was cleared by his political party, and his name forwarded to IEBC, and the IEBC invited him, and even gave him a time schedule for presentation of that particular nomination, those particular nomination papers, he expected that if he qualified as a candidate, he would be cleared to run for the office of governor. He was.
So his first statement says he ought to contest.
Yes. He ought to be cleared under Article 88, and under Article 88 to run for the position of Governor of Mombasa. In exercise of his political rights as espoused under Article 88. Your Honor, he presented his papers with all documents. Now the contest was the decree, first of all, was the decree that the degree certificate, the certified copy of the degree that is presented. Was it a valid document? Your Honor, it was a valid document, but because it was certified by an advocate of the High Court, and there was no criteria set. It was not specifically indicated that an advocate could not certify such an advocate. So why would he not be allowed? There was no provision that he had to produce an original. And in any event, Your Honor, under the rules, under the election regulations, 2012, specifically regulation number 43.5, a returning officer has a leeway and actually quite a latitude to even allow candidates to regularize any documents that may not have been regular, as long as the documents are there. And indeed, he had the document. And you'll see when we come to our presentation, you'll find that he did all that he could, including even producing the original certificate and a certified copy from
Get around. I'll get some more people will give opportunity to address you in future. Thank you. Yeah. Two things. The returning officer, you might have a submission. Commissioner of he addressed himself to an issue that is not very qualified at all. That is on section 75, subsection 3. And he was not aware of Article 75, Article 3. He was not aware of Article 193, sub-Article 3, which makes it quite clear that when proceedings are still pending, then one does not have to suffer prejudice at all. In this particular case, proceedings are pending before Superior Court, and I have personally appeared before Superior Court in this proceeding. And this is my humble submission, Mr. Chairman, without taking much of your time, that on this score alone, considering that the returning officer is not an expert on the law, he committed a grave error in not nominating or permitting the governor to be participate in the forthcoming election. One final word that I would like to say is to the committee. Let us not forget that it's a right of every Kenyan to participate in the process of election.
And that's something we must.
That is really what we stand for. Democracy, the 2010 Constitution. And that is what people fought for. They shed blood for, that they may be able to elect their own leaders. And they go further. There are some people here who may probably criticize me and say, it does not matter what they are. The last word is to the electorate. It is the people.
Let the people decide.
Precisely. That's what. May I sit down?
Thank you. Thank you. We have all learned a lot from you.
Yes.
I think you are appreciated a lot by all practitioners. You have talked
very well. Can I say something, Your Honor?
Yes, yes.
Give me 150.
I have served Mr. Nyano, and I have served Mr. Mokele for IEBC. So they're now properly on record.
Okay, thank you. So that we address that administrative issues, Mr. Oginga,